on remaking the nation's healthcare system over 200 years after they were deemed to have received that power? And the answer is simply that the Founding Fathers knew what those words meant and that it did not give them this power. And the evidence lies in the answer to the question. Has America been plagued by frequent disputes between various states about medical care? And I would think you would have to agree that we have not experienced this in the past. Secondly, let me be so bold as to ask the Congresswoman, is the Commerce Clause the authority to pass legislation funding trips to the moon, space telescopes, space satellites, stem cell research, and any other purpose not known to the Founding Fathers? Because none of those powers were granted to Congress either. And it is very obvious to conclude that she is not telling the truth when she makes this claim, because she must know about the power to legislate in all cases whatsoever given to her in the U.S. Constitution. But she still has been instructed to not tell the American people. In other words, she has been instructed to take silent judicial notice of this fact. So she makes up this absurd claim to cover the fact that she simply cannot tell the American people the truth. And I will explain why this legislation is being considered and quite likely will pass towards the end of this presentation. But suffice it to say that I believe that Congress does know that they have the unlimited power of Article 1, Section 8, Clause 17, the power to legislate in all cases whatsoever. In other words, they have the power to do whatever they jolly well want to do. Yes, the sign on the podium in front of the Congresswoman tells us what she believes in: a new direction for America. Congresswoman Pelosi believes in a broad power to do whatever she and the majority of the Congress wants under the Commerce Clause. Apparently she had never read this quotation from Thomas Jefferson, the principal author of the Declaration of Independence and the third President of the United States. This is what he said about the Constitution and her liberal interpretation of the Commerce Clause. Free government is founded in jealousy and not in confidence. It is jealousy which prescribed limited constitutions to bind down those whom we are obliged to trust with power. That our Constitution our Constitution has accordingly fixed the limits to which and no further our confidence may go. In questions of power, then, let no more be said of confidence in man, but bind him down from mischief by the chains of the Constitution. It seems to me that Jefferson was certainly a champion of delegated powers, meaning that Congress has only very specific powers. To bind Nancy Pelosi down from mischief by the chains of the Constitution. But of course, Nancy Pelosi knows more than James Madison and Thomas Jefferson. I will say this: if we allow Nancy Pelosi to extend the power of government into every corner of American life under the Commerce Clause, we will surely have a new direction for America. Next, I would like to provide you with some evidence that my contentions, additional evidence that my contentions are correct. First of all, I would like to include parts of a letter I received in August of 2009 from a practicing attorney in the United States. I shall not name this attorney because I will protect his privacy, and because I am certain his fellow attorneys would not appreciate his putting these thoughts into writing. He was responding to an appearance I made on a talk show in his area wherein I discussed the Supreme Court decision that totally eliminated the Constitution and the common law. I then discussed the evidence that we were living under the Uniform Commercial Code. This is how he described himself. I am an attorney and I've been practicing for 14 years. And I am licensed in 3 states. And have actually been blessed with the opportunity to be involved in cases all over the United States. He then wrote this: I enjoy and applaud your work. I've come to the same conclusions on most issues so far. And to some degree, I am still working on it. And then he added this comment: I've heard this argument many times that there is a big secret underlying the modern court system, which is actually a uniform commercial court. And the lawyers and judges guard the secret, like they were part of some secret society. And that if you say the magic words or indicate that you know the secret, the judges and lawyers will know that you were on to their big secret, and you will be given special treatment. So once we tell the truth, it is no longer a big secret, and I just did. Let me give you one more bit of evidence that the Constitution is null and void and that the Supreme Court knows this. This is, of course, Barack Obama, recently elected President of the United States. And this is a picture of the President with his mother. And this is a picture of the young President with his father. A citizen of Kenya, a nation on the eastern side of Africa. And this is the future president in a picture taken in Kenya. He is the second man from the left in the back row, as shown in the red rectangle. The woman in the bright yellow dress is Barack Obama's grandmother, the mother of Barack's father. She has been quoted as saying that Barack was born in Kenya, and that claim has been substantiated by his half-brother and his half-sister. Now this poses a real problem. The Constitution of the United States says this about the qualifications of the President. This is how Article 2, Section 1 of the Constitution reads. No person, please notice the word is person, no person except a natural-born citizen shall be eligible to the office of President. And those two words, natural-born, means that the person has to be born inside the 50 states of the United States of America. Therefore, if Mr. Obama was born in Kenya, he is a citizen of Kenya. And since he was not born in America, he cannot be president. And Philip Berg, an attorney from Pennsylvania, has filed a motion in the Supreme Court of the United States in 2008 asking them to decide if Barack Obama is constitutionally eligible to become president. I was able to call in during a radio talk program prior to the inauguration of Mr. Obama in January of 2009 when Mr. Berg was a guest of that host. And I told Mr. Berg that I wanted to thank him for his attempt to ask the Supreme Court to declare that Barack Obama could not be inaugurated as president. And then I told him that the Supreme Court would not give him any answer ever. And that the reason was because the Supreme Court knew that the Constitution was declared null and void in 1938 by the Erie Railroad versus Tompkins case. And that the Supreme Court, like all courts in this nation, has taken silent judicial notice of that fact. It is now December the 28th, 2009, and the Supreme Court has still not issued an opinion as to whether or not Barack Obama is constitutionally eligible to be president. And Barack Obama remains in office. It is my opinion that this reluctance of the Supreme Court in nearly a year to afford Mr. Berg an opinion is further evidence that the Constitution of the United States is null and void. And that the Supreme Court knows that. And that they too have taken silent judicial notice of that fact. And as I have already said, they will never issue an opinion. Now let me briefly explain what the Uniform Commercial Code is. It is called the law of contract. It changes everything in America to a contract, and since two-party contracts have to be agreed by both parties, neither party can force the other into a contract. This is the reason that they cannot force us into any contract without our consent. Now this posed a problem for the international bankers because they knew the courts will declare any contract where one party forces another into signing it null and void. And the reason is that forcing someone into a contract against their will is called involuntary servitude, and is in violation not only of the Constitution, but of the Uniform Commercial Code as well. So they somehow had to make us believe that we had to sign for a contract, even when they knew there was no law requiring us to do so. This is called color of law. It sounds like a law, it acts like a law, it has the force of law, but there is no law. Let me explain this in another way. Congress has been given the power to make us believe there is a law when there is no law. Now let me show you how this works. Before I do, I want to explain that this is only a brief review. I am not an attorney, so I cannot give you legal advice. All I am trying to do is cover this story as an historian. I'm relaying information that I believe to be true as a way of educating the American people like any historian does. Now let me start. There is no law requiring any of us sovereign state citizens to get a socialist security card. So they trick us by making us believe that we must get a card when it is a voluntary act. But you say everybody knows that you have to get a socialist security card to get a job in America. But I ask those who make this statement, please show me the law. And no one has ever been able to do that. Now let me ask you to consider this. I am a self-proclaimed honorary citizen of the state of Missouri, which is called the Show Me State. That means to me, if you have something for me to consider, please provide me with some evidence. So I will now try to provide you some evidence that there is no law. and I submit the following two letters as some